sorry, I don't know names, so maybe you could introduce yourself and then ask the question.
My name is Vipul Mudgal. I work for Common Cause. Harish, you were at your kind of poetic philosophical best. I thought it was a discussion on legality, but it's turned out to be a discussion in philosophy. So I have a comment and a question. I mean, the comment is that, while reading Amartya Sen's book, The Idea of Justice, I saw a new way of looking at these exalted notions of liberty, freedom, justice. They become very exalted. He says that there are so many remediable injustices around us that if you start looking at injustices, probably that's the best way to see understand the issue of justice. So, justice seen through injustices, freedom seen through unfreedoms all around us, and exclusion, the way the society is working actually is through exclusion, not inclusion. So, I mean, this is my comment. And my question is, do you think there should be a gestation period for lawmaking, which means you have a green paper, white paper approach, and a compulsory gestation period of about, say, 6 months or 8 months when drafts are kept in public domain, for public discussion, so that there is both pre-legislative transparency and time for participation of the people whose lives and livelihoods are affected by those legislations?
See, the answer to the question is no doubt about it, and this is something we had written to a few political parties as well, saying that include this in an agenda, that any bill that is to be introduced, put it up for public comments, 3 months, 6 months, whatever it is. I mean, there are always emergency requirements, leave that out, but most bills are not made in a hurry, right? They're made in a hurry only because you have left it till the last moment. But you need to put it out in public and invite comments. It happens only on certain statutes, right? Like it's happened on the Companies Act, because it was like 30, 40 years in the making. It's happened, in a couple of other things, but it doesn't happen as a matter of routine. And it's actually worse at the states. We only focus on Parliament. I think the real problem is the state level, right? It's a complete black hole. Nobody even knows what laws are being made on a yearly basis, and even the ministries themselves don't know what the laws are. So that is a problem. So I'm totally with you. We need something like that. I totally agree with you.
Thank you. This promises to be a very fascinating book. I look forward to reading it. I wanted to ask you, so it seems that the book sort of centers around the Constitution as being the source of the rule of law principle, right? And if the rule of law is understood to be deriving from reason, however it may be defined whether by Dicey or Aristotle or Montesquieu or others, I would submit that the Constitution itself has much of unreason in it. And in the Fundamental Rights chapter, actually, the provision that protects all colonial laws, and we have so many of them, and none of them were devised with reason as the motivation, but rather to satisfy the interests of a colonial state. So, how would you sort of, have you addressed that in the book, and if not, how would you address it here? And I'd be very, very interested also in learning about the methodology of the surveys that you used for some of the findings that you have and the indices that you relied upon, because my own experience with indices is that they're very far from the reality in the area of land that I work in. And I just wanted to push back a little bit on, I completely agree with you on the 10th schedule, which I do think has really helped to sort of make party structures more authoritarian and parliamentary discourse less democratic in terms of deliberation and engagement. But I'm not entirely sure how institutions have become less, sort of less compliant with the rule of law over a period of time. I don't see it in my own work. I want to particularly stress on the example of Parliament that you gave. You didn't really speak much about the executive, and my own view of the executive is that it rarely sort of complies with the rule of law. It has to be sort of brought to comply with the rule of law, whether through parliament or the judiciary. And that too, I think, is a function of the fact that it's a post-colonial executive with very little change from the colonial period. But in terms of Parliament itself, I mean, if you look at our Constituent Assembly debates, there's very little debate on any of the provisions. In fact, if you look at the history of the Constituent Assembly debates, we find that most of the debate actually happened within the Congress party. And most of the provisions were sort of based on the consensus that was derived within the Congress party. So there's actually, even though we have a lot of representation within the Constituent Assembly from other groups as well, who unfortunately in a more majoritarian parliament setting probably don't have the same kind of representation, the fact of the matter is that our constitution was also, if debate is the indicator of how democratic and how compliant with the rule of law we are, I don't think that even our constitution was that compliant with the rule of law. And therefore, we do find a lot of views that are not really there within, and a lot of compromises and things that are. I mean, I work on property and land, and if you see the discussion on the property clause, there is very little discussion. So, for instance, Article 19(1)(f), which essentially safeguarded everyone the right to use, hold, and dispose of property. I mean, the reason why this provision was introduced was because many people, like women, like certain castes, were prohibited from holding property in land and in certain other assets. And the reason why that was not even part of the Constituent Assembly discussions was because there was a whole group of people who were already debating the Hindu code, and they didn't want it to be in the constitution. They wanted to bring about the reforms of these religious laws through parliament and so on. And so we don't even find that discussion there. So there's just very little debate in the Constituent Assembly. So if you could address those points.
See, on the executive, I agree. I don't think we can. I don't think I can see a decline in the executive's compliance or non-compliance with the rules. Okay, and there's not that much data. I mean, you can only, maybe if you really want to take a hard look at it, you look at the number of writ petitions that were filed in the 1950s and the number of writ petitions that are filed now. Maybe that's an indicator if you're challenging, executive action, if you want hard data. Otherwise, executive non-compliance with law is very difficult to measure on a day-to-day basis. So you could take the number of writ petitions as an example. That's an area for research, and I point that out. That you just have to sit in any high court on any given day, and you can see the shades of executive non-compliance. But my point more in terms of Parliament is just taking hard data in terms of how much time, how many times do they meet, how many bills they legislate, and the quality of the debate, and the time, more than the quality, the time they spend on debating some of the laws that they have passed. And it's been more, in the 50s and 60s, and less time now. So that is, just in terms of amount of time spent. See, in terms of the Constituent Assembly, I haven't really examined whether the Constituent Assembly, satisfies the test of the rule of law. What I instead start is that, the Constitution was a choice that we made. Okay, unless now we reconvene somehow a new Constituent Assembly, it's a choice that we have made, right? And that is now the choice that is set. So, whether some of the choices were unreasonable when they were made, probably yes, but it's part of the, there's a lot of debate about, all the provisions on reservations, for example, right? So whether it's reasonable, unreasonable, but that's a choice, a political ideal that they made in terms of achieving substantive equality. So that, I think, so I leave it at that. But in terms of, some of the, provisions, even the IPC or, things like that, yes. But I don't think we should take the Constitution provision to give protection to some of those statutes as the final verdict on that. I mean, independent Parliament was supposed to examine that, right? We are supposed to examine our laws, which we don't do on a regular basis. So, all political ideals by nature, okay, all political choices at an ideal level can be, unreasonable at times because it's a choice. And on substantive choices, it's very difficult, as I mentioned, to say which side of reason you fall on. So I think I don't necessarily agree that that the political ideals embodied in the Constitution would have been something else if there was there was a different kind of constituent assembly, because I think, and if you look at scholarship on this, at that stage in India's history, we didn't have the choice but to adopt some of these principles, right? And this is historians who have reviewed this. So I agree. I mean, whether it could be X or Y is something we can debate on. But on some of these colonial era provisions, I totally agree. I think Parliament needs to look at it, and we're not doing it.
Lavanya?
Harish and Ritan, I'm looking very much forward to reading the book. Like Namita, it sounds fascinating and provocative as well. My question relates to the notion of rule of law itself. As you made very clear in the course of this conversation, the notion of rule of law is not clearly demarcated, it's not clearly articulated, and it's not directly tied to the political ideals of our country. And I guess my question is quite simple. Have you actually examined and considered what accounts for it, and whether there are any benefits to actually having ambiguity in this notion of rule of law? In particular, is it a constructive ambiguity, and is that something that judges can use to be provocative? Pratap Bhanumehta talks about the jurisprudence of exasperation that our judges engage in, and is there some sort of constructive element to this ambiguity in the rule of law that our judges are able to harness to deliver outcomes that perhaps we need given the context in which we function? It's not necessarily what I believe, but I think it's an interesting question to ask, and I wonder whether you've thought about it. Thank you.
So, again, I think I want to nuance that a little bit more. I mean, nuance your question a little bit more. So there's institutional functioning, judiciary as against the other two institutions, because judiciary has a set role in how it deals with rights and enforces rights and all that. And then there is the overall rule of law, including all three institutions. So if you examine the overall rule of law, then my comment is that all three institutions are failing in reasoning. And then we go into how each institution is functioning, and I discuss that in one chapter. But then if we start looking at the judiciary, there are two things, and one of the things I think what you're adverting to is this charge of judicial overreach, judicial activism, making laws, all of that. So I have two, three comments on that. Yes, there are cases when there is a clear, crossing of the, sort of judicial, line, if you ask me, because separation of powers means that you need to stay within your own boundaries and also respect others' boundaries, and that only enhances your independence as well. But for me, the judiciary, I'll come to, I'm not escaping your question, I'll come back to that, but for me, I want to make a different point. For me, the judiciary actually is not hard enough on the executive. And that's the point I make. And that is actually causing the failure of the rule of law. And, both Kannabiran and Arun Shourie, two figures from two different, philosophies, point out that the judiciary on a day-to-day basis believes in being gentle with the executive, right? They need to give them more time. They say it's almost like we need to persuade them to act better rather than crack the whip. And then you have certain cases which hit the front pages of newspapers where the judiciary is told that they are overreaching. And if you examine the total number of cases, and recently we've written a paper, it's not yet in the public domain, the percentage of cases where you can allege judicial overreach in terms of policy making, divorced of any rights issues involved, which is judiciary's job to deal with protection of rights, is very, very small in terms of the overall number of cases that you take. So that's why I say this judicial overreach is exaggerated a lot, because that's in the public domain, all right? And it's a fair point. It's a point that we need to tackle, because that actually addresses the rule of law problems otherwise, and that is the jurisprudence of helplessness or jurisprudence of exasperation as Pratap talks about, right? And that is there, and we can't avoid that. There are many examples of that. But that, my view is that is a very, very tiny percentage of what the judiciary is doing on a day-to-day basis. And in the majority of the cases, the judiciary is not sufficiently enforcing rights against the executive, right? And that is, it's there in our case law, as lawyers, when we read case law, we see that, there's always given, they said they're given more time, and they say, okay, we'll remit it back. It's not just in judgments on a daily basis. Say, okay, we'll send it back. The executive to exercise the discretion better, to take more, things like that. So there's a lot of things happening. So executive is given a very long rope, and judiciary, more often than not, rules in favor of the state when the citizen and the state is, are fighting in cases. And this is reality. If we do a hard analysis of all the cases that come before the judiciary, that's there. Now coming back to this, to the question that you're advocating. Yes, I think the ambiguity in certain principles helps the judiciary to read, more powers for themselves, right? And that is one of the criticisms, like, some theories like Unger and critical legal theories make, that the law is never determinate. There's always an indeterminacy, and personal philosophies of judges and institutional philosophies come into expanding the law, and therefore, accruing, and aggregating more power towards oneself. And there is an element of that. But in terms of understanding the rule of law, as against, say, interpreting Article 32 or Article 142, I think in terms of Article 142 and 32, I can buy the argument that there is a reading, widely sometimes to increase the power of the judiciary. Sometimes, justified, sometimes not. But on the rule of law as a whole, I think all of these individual actions of the executive undermines the rule of law. Whether you are increasing the power or refusing to, to go as much power as you have. And Kannabiran actually, he writes beautifully on this issue. He says, if you keep persuading the executive, they're not going to listen to you. You're talking about rights, and you need to enforce rights against the state, and you need to take a hard stand. The judiciary needs to take a hard stand on certain issues. So that doesn't happen. So it cuts both ways. Unfortunately, we're all focused on judicial overreach and not on the other issue, which I think is more of a problem for the rule of law. Judicial overreach is a minor problem according to me, but it has an impact because it's in all the big cases and not on the daily cases of rights of citizens.
There are two unexplored areas, I think, in your book, and my comment is based only on looking at your index, because I told you I haven't yet read your book. Firstly, you've talked about judicial delays and the judicial system in a judge-centric way. You have perhaps not explored the role of the legal profession and how it acts as a dampener, both because of the lack of quality control in India and also because of its unaffordability in terms of access to justice, which I believe is an essential component of the rule of law. Secondly, you've dwelt on the 10th schedule, and I'm making this comment in the context of the representative character of Parliament. Perhaps you have not explored how the first past the post system also detracts from the representative character of Parliament, and how would you compare the first past the post system in India compared to the country where it came from in terms of the rule of law?
I haven't examined the second point, sir. That is proportional and first past post system. I haven't examined that at all. The access I've very briefly touched upon, not in great detail, but I have touched upon access to justice, access to the courts, and also actually discussed briefly about PILs and Lok Adalats. And I've made some, I make some comments which may not be to everybody's liking. But lawyers have not dealt with in great detail, and I agree that there is a problem. It requires an independent study altogether. But PILs and Lok Adalats, I think, are a problem for rights, because PILs and Lok Adalats are, if you look at it from a pure rights perspective, PILs become necessary because rights are not enforced in the first place. So while PIL was a great development when it first came on, my question is whether they should continue for so many years. I mean, it's 40 years since, 40, 50 years since the first set of PILs came out. And the continued use of PILs for rights enforcement, say things like bonded labor or, manholes and, things like that, actually comment on the lack of rule of law when it comes to rights. So that is my problem. So I think, again, my view is that we are misreading PILs, but it's good to celebrate that the courts have opened the jurisdiction and allowed representative filing of litigation. I don't have a problem with that, but the continued use of that is a problem. And for the same issues again and again and again. And that actually speaks volumes about the rule of law. Lok Adalats also, I think those of us who see how Lok Adalats function, I think you can actually call them a fraud on the rights, because people are forced to settle, right? So it's the kind of cases that come to Lok Adalats. There's a lot of good that happens, but if you look at from a rule of law perspective, a forced settlement is not, a satisfactory answer to a person who suffered a violation of right. And you can ignore the edge cases like Motor Vehicles Act and things like that, insurance claims, all of that. But Lok Adalats for all kinds of cases is a problem. So access is there, and while the two methods for solving access is Lok Adalats and PILs, they do have problems from a rule of law perspective. Legal aid, I haven't dealt with that much.
See, in your, in your talk, you made a statement that the Indian Parliament has not devoted or is not really, has not displayed its effectiveness in developing a theory of rule of law in this country. While most of the developments in terms of theory as well as practices has come from the judiciary. It's a very fair statement, we have made it. I just want to know, if you compare the other parliaments of the countries, maybe the West, which calls itself the citadel of democracy, we also call it the largest democracy and claim a lot of things in the name of democracy. How far those parliaments have fared in terms of developing the theory of rule of law in their respective countries? So this is one thing I wanted to know. I have so many other questions, but I'll restrict to one.
It's a valid question, sir. And I have not done a detailed analysis. I can only speak from, if you take one facet of the rule of law, and this is a problem because rule of law is not only a judicial thing. For example, the supervision of the executive is through parliament and through legislature. That's the first step of accountability under the rule of law. And if you see other countries, take the US or even the UK, the amount of legislative and parliamentary supervision of executive action is enormous. And here we don't do that enough, right? It is not the judiciary's job to supervise executive on a daily basis. It's the parliament's job to supervise executive on a daily basis. It's the judiciary's job to point out and rectify violations by the executive. But that task has been abandoned almost by our parliament. Yes, there are some examples, but that is a problem. And if you compare, even on an, sort of just a casual reading, you'll see that other parliaments are much more effective.
My name is Sagar. So I have studied some part of law in cost accountancy. So I would like to ask you one very basic question. That when we create a law, we either go through the consciousness of the common sense, or we go through the customs, or we go through the subject conditions, or we go through the other laws in the other countries. So what is the basic of your creating a law as a law?
In my view, it doesn't really matter, as long as there is clarity on what you're doing. Okay, I don't particularly believe that borrowing ideas from other countries where it's been successful is a bad thing. But whether you borrow it blindly is a problem. Okay, whether you then customize it using your own, using to local conditions, or to develop your own philosophy, there's no problem. So I don't think we should say, and I think there's this famous debate between Tagore and Gandhi about how you need to keep your windows open. So you let all the winds and ideas come through. So I don't think I'm so worried about whether it should be indigenous, whether it should be borrowed, not borrowed. The problem is when you do it in a manner that is not thoughtful and not discussed properly. I think that is the issue more than where it originates. For example, a lot of people say, and this is a complaint about the Constitution, and there are some the recent leaders who talk about how the Constitution should be rewritten. And can you imagine a Constitution without equality? And can you say, oh, we have had 5,000 years of inequality, so let's continue with that? I think it's sort of a meaningless discussion. So just because we borrow ideas from other people doesn't make it invalid. It makes us better. So I don't think that's the problem. I think the problem is how we do it. The process of doing it is.
We'll take the last couple of questions if there are.
It's being recorded, so
Sir, my name is Sudhir Chopra. My question is that how do you think that major threat to rule of law comes from the state and its functionaries? How far our judicial system has been able to tackle this aspect? As far as individuals are concerned, there are so many penal laws, they can be put in jail or fined, but state and its functionaries, they mostly go scot-free. To what extent judicial system has been able to take care of that?
See, I don't know. See, you can look at it. I mean, it's almost like a glass half full kind of answer. I mean, right? But see, I don't think it's easy to sort of weigh. Have there been 60% successful, 20% successful, 90%? I don't think it's in abstract. It's in absolute terms. I think in terms of reinforcement of rights, the judiciary has done a fantastic job in terms of reinforcement of rights. The problem that we find more often is in the final, benefit of how those rights come at an individual level. Okay, so in terms of declaration of rights, for example, just if you take Article 21, and the lawyers, in the room will know that we have read in a whole host of rights into Article 21, and it's a great thing. And even Article 14 and equality, how you have viewed equality, it's a great development, and the judiciary has done a fantastic job on all of that. My point is something different, and it is in the daily enforcement, and that's the one part of your question in terms of vis-a-vis the state. Has the judiciary been strong enough is the question. And if you look at it in that fashion, activists who have written about it regularly feel that there is a gap in terms of the final enforcement. And I examine a few cases, both for example, in terms of bonded labor, in terms of, the PUCL cases, and then, Sheila Barse's case and other cases, where mere grand pronouncements on rights don't necessarily mean that they translate into effectiveness of rights against the state. And there is a problem at another level, because, and to some extent, the problem is more with the parliament and the executive and less with the judiciary, but rights are seen to, or are being seen as something that the state gives, rather than something that citizens have. So I deal with this concept of rights versus entitlements. The state seems to think that, say Part 3 are just entitlements the state has given, and they can take it away at whatever stage they want. And you know, we have had a case on the law books for many years, which has been set aside now. You know, the habeas corpus case, which sort of gave justification to that kind of thinking. But if you take it at a very, very operational level, this entitlements versus rights is a serious problem. Okay, at every level that you interact with the state, and when I say the state, it's the executive, not necessarily coming to the judiciary. And there, the problem of enforcing with the judiciary is the problem, because it takes such a long time. Nobody wants to go against the executive for every small thing. Every interaction with the state is as if your right is merely something that they have granted, and they can decide at each level whether they agree with it or not. And that is a problem. And that is the core that I'm focusing on, rather than, you know, pronouncements by the judiciary. And in terms of, you know, assertion by the judiciary of rights, you know, we have a very good record. I don't think we should say that the judiciary has failed. I think the judiciary has been very successful. Where the judiciary has failed is, in my view, is in the enforcement at a daily operational level, because the problem is more difficult, and enforcing those rights at an operational level, going to the judiciary is a difficult issue.
I think we'll just close it here, but just to express our acknowledgement and gratitude to, I think Justice Lokur is here. Justice Lokur, would you like to make a few comments or speak through your judgment? Okay.
Thank you.
Now I think then, should we just take one last, Yamini, do we have time for one last question? Or? Yeah, okay.
How do we increase enforcement outside of the judiciary? Because it's really not the judiciary's job. And I think the Western world is sometimes find it very funny that we file so many PIs to get things done. Sadly, there's no other way to do it, and thank God for the judiciary. But that's not the way we can sustain. That's not how healthy democracy can get there. So just one or two quick thoughts on how we can get that burden off the judiciary and actually make the rule of law function.
See, it is a...
Big thoughts.
It is a...
It's a thing. I mean, it's volumes and volumes.
No, it is a, and this goes back to what Lavanya talked about earlier in terms of, you know, jurisprudence of exasperation and intervention because of exasperation, right? And why are you not doing it? And I remember, you know, talking to a few judges about this as well, and they said, listen, what do you want me to do when somebody comes and complains of rights violations? Will I say, listen, this is not my job, go to the executive? Or should I do something about it? Because I am the last hope, and that explains some of the interventions by the judiciary, and we should. But in the sense of the rule of law, that's a problem, and you're right. What is the answer? What has happened? And you know, you more if you interact with the bureaucracy today, they do not take any decisions. They actually say, file a PIL, get an order, we'll implement this, right? They encourage you to do this. So that is the issue.
Almost spread a culture of laziness.
Yeah. So whether it is because, you know, there's an overreach by the judiciary trying to do somebody else's job, I don't know. I think we have gotten ourselves into this, you know, sort of rigmarole almost about, you know, how do you go through these things. I don't have an answer. I'm sorry, but you know, I don't have an answer.
We can work together.
Yeah.
To add to that, I mean, I think it goes back to the ambiguity point, which enables a context where the institutional strength, the narrative of institutional strengthening doesn't become priority for institutions. I mean, it's quite incredible that inevitably the executive functions most effectively when the courts enter the picture, not when the political moment, which is how it should be, pushes the executive in a particular way, right? And it sort of seems like everyone has got and you know, think of how activism works too. It's the courts have become the tool now, so everybody has got comfortable in this context where there's a powerful tool that can be used whenever necessary to push the executive to operate in a particular way, which then closes off the larger conversation that needs to be had, which is how do you fix the rule of law more broadly, so that becomes a business as usual mode as opposed to a constant knee-jerk reaction to pressures that come in this way. And to have that, activism also needs to think about itself very differently. You now need to start talking about institutional strengthening, but that's not going to get you mobilization on the streets. So we've got caught in that somehow.
I think as I said, yeah, I think Parliament, as a start, there should be more legislative supervision of executive, and capacity building, which all of civil society organizations work. Political, I mean, that's also right, and I talk about it in the book, but we don't have time here. But this we need to do.
Themselves, I think, are increasingly seeing their role less as legislators and far more as gap fillers.
Yeah.
So what does an MP spend most of their time doing, and what do they think determines an election for them? It's how many schools I can provide, how many roads I can build, how much MP-led fund I can use. That's the narrative of an election.
Absolutely.
Not what you do in parliament and how many bills you like.
I agree with you. They want to be CEOs
so
of their
you're caught in
constituencies.
a...
Yeah, I agree with you. Yes, and unfortunately, I think the buck finally stops with all of us, right? And as citizens, we vote them, right? And that's how democracy functions. And there's, again, Justice Leela Seth in her book talks about how citizens have actually done a good job, and she talks about she coins the phrase initiatory democracy, because citizens have gone, filed PILs, pushed for legislations, all of that. For that to happen, and I go back to the point I was making in the context of the 10th schedule and all of that, there's not enough initiative given for legislators to come up with new policies on their own. It's left to a few people in each party or in the executive. So there is not enough. I mean, I discussed also the number of private bills that has ever been brought in the parliament and legislature. So in terms of two things about the legislature and parliament is, one, in terms of policy making, two, in terms of supervision over the executive, and that also feeds in as citizens. We can't seek direct accountability of the executive, right? I mean, the theory is that we vote people in and they go and make sure that everything works fine, and then we're all happy. But that's the theory. So I think how does that work is a question. But overall, there is a if you look at it from a rights and rule of law perspective, there's a gap in how institutions are functioning. I think that to put it very sort of simply at the end of it all.
Great. No, thank you. I think that was a good discussion, and I don't know whether we take it. Is it tea outside? No. Okay, we're done. So there's books outside. Correct. And so yeah, I think the book is outside and it's for sale. So thank you everybody for attending. Thank you.